We are live? Perfect. Okay. So Priyanka, you can, I guess we are doing the 30-second. Okay. So Priyanka, you can open up the session.
Okay. So, hello everybody. GUSEC is India's leading startup support system and is India's only incubator which provides startups with 0 day and zero cost support. In the span of 4 years, we have supported more than 200 plus startups and currently have 120 plus startups incubated with us. Our startups have cumulatively crossed 14 crores in revenues and have generated more than 660 jobs. We provide our incubatees with free co-working space, mentoring, access to government grants, funding opportunities from investors, intellectual property filing support, and IP awareness, access to laboratories and infrastructure of the GU ecosystem. GUSEC is also a nodal body of Gujarat University to look after its IP-related efforts. Till now, more than 200 applications received who were further given the guidance and mentorship related to IPR. GUSEC also supports filing any patent or trademark financially to GU students and startups. More than 50 patents, trademarks, and other intellectual property has been facilitated by GUSEC. If you want to know more about the startup incubation applications, IPR support applications, and support available at GUSEC, then you can go for the website that is gusec.edu.in. So I would like to thank Ms. Anjula Mehta, the CEO of IPPO, that is Intellectual Property Organization Protection Organization, for their partnership in organizing this interesting workshop. Now I welcome Anjula ma'am for their participation and for the partnership with us.
Thank you so much, Priyanka. It's a pleasure to be working with GUSEC on various programs that we've been doing in the past. And this is again an interesting workshop where this is a certificate workshop. And IPPO has been working in terms of creating awareness on intellectual property to the academics, to the startups, to the corporates. And joining hands with GUSEC is a pleasure. And we look forward to doing more programs with them.
Thank you so much, ma'am. So moving forward, I would like to introduce about our speaker, which is today we have Ms. Gopi Trivedi, who is engineering and law graduate by qualification, is a registered patent agent and a senior partner at yjtrivedi&co. Her academic qualification of being an engineer, together with a patent attorney with work experience in the legal fields, is itself a testimony to her being professionally surpassable. Adding to this, she also holds CPVA, which is Certified Patent Valuation Analyst. She has been recognized and awarded by various institutes and industry bodies as patent expert and well versed with academic institutions. She has also been recognized at the Times Power Women 2018 as being among the top 50 women achievers by Times Group. Also awarded by the Business Women Wing of GCCI with the Women in Business Excellence Award in 2017-18. Recently, her firm YG Trivedi & Co. has made a world record in filing maximum number of patents in a single day under her able guidance and leadership. So I would like to welcome you, ma'am.
Thank you, everyone. Thank you, Priyanka.
So I would like to hand over to Malay to further.
Yeah, thanks, Priyanka. Thank you, Anjuna, for agreeing to organize this interesting session with the subject of creativity and intellectual property, how they go along. It's good to have you, Gopi ma'am, for this session. Before we begin to talk more about creativity and intellectual property, GUSEC always emphasized on its objective to convert at least 1% of its students or research scholars to into a entrepreneur. So it's a very bare minimum realistic goal that we work upon, that how a student can think of out of box thinking ideas and come up with a certain solution which are relevant to a more pressing problems nowadays. Uh, in this pandemic and whatever the situation we all are going through, it's a bit of a new normal that all we are adopting with mask and certain precautions to make sure that we are safe. We all are also exploring a new ideas that how can we tackle the situation. So it's always good to have new ideas from the students, because they are very prone to a new thinking, as well as they can literally develop new innovations, where we can come in and make sure that these ideas go to the next step. In terms of creativity, we always think it's a very difficult. It's not a rocket science. If you see, India is a country of nearly 130 crore people. At the same time, we also have some kind of challenges that is we are witnessing in India, and as the necessity is the mother of invention. We always think about these challenges, that challenges, but at the same time, some students come up with their innovative ideas that ये idea ये चीज में आपको help करेगा. On the same lines, we also run a accelerator program to find the innovations around COVID-19. So around 450 good applications, out of which 27 ideas have been selected. So it's again a very interesting thing to look out for, that students are bubbling with new ideas, and we at GUSEC are looking forward to support them in whatever possible manner. And where we talk about the intellectual property, there are certain businesses that solely dependent on securing that intellectual property, because somehow not every startup can do a patent or trademark. But yeah, there are certain ideas which has to be done or secured with necessary IP, so that the whole business model can be secured, and the commercialization of the product can be done. So going forward, I guess Gopi Madam is going to cover almost all of the topics. So without wasting a moment, I'll pass the baton to you, ma'am. Gopi Madam, over to you.
Okay, thank you, Malay. Thank you, Priyanka, first of all, for elaborate introduction. But I'm just one of the passionate techno-legal person and would really love to work with GUSEC. So far, it has been a wonderful journey, and all the participants, it's a wonderful place to develop yourself, develop your startup, and cultivate your creativity and intellectual property. Thank you, IPPO, for having me here as a speaker. It's really a privilege. So, my dear participants, I'm here to talk about, as the topic says, it's creativity and intellectual property. I hope I'm visible and audible.
Yes, you are, ma'am. Yes.
Yeah. Okay.
Yes.
So, the topic, as it says, creativity and intellectual property. It is quite a much talked about topic, and it is much in the imagination also, that what can be creativity, how can an individual cultivate the fruits or benefits of creativity and really materialize it. So throughout the session, I'm going to talk about different types of creativity, different forms of protection, and their intersection amongst all of them. So I'd like to quote by one of the quotes by Mr. Ratan Tata. He's always been talking about creativity as creativity is a flagpole of innovation. First step. Moving ahead, the other prolific innovators or prolific speakers who have motivated themselves by producing unique products, as well as they have also motivated the youth and innovators around the world. And Steve Jobs have always been saying that you have to be really burning with an idea or a problem or something wrong that you want to make it right. And if you're really passionate enough, from the start, you'll never stick it out. So, burn yourself with the so-called idea, so-called problem, and make it happen. That's the philosophy, right? So what goes around? So keep thinking about a problem, keep thinking about its solution, and add on your thoughts or add on your own individual creativity and make it happen. And then those creativities shall be protected eventually. That's the underlying theme. So on the screen we have various logos, and I'm very sure that my dear participants' mobiles must be having all or many of them in their mobile as the app, or they may be the regular users of such apps. Now we as user have made our life easy, productive by using such apps. Now let us think about those who created such apps or such services. Maybe an OYO rooms for a particular purpose to offer economical rooms to the users. At the same time, Book My Show to make booking efficient and quick, and payment may be made in a jiffy. You don't have to stand in a queue at the viewing place, maybe theater or exhibition centers, etc. And all your booking is done in no time. So these or kind of apps have always been developed keeping one difficulty in mind, one problem in mind, or few more problems in mind. While solving them, they always kept the users or consumers in mind, and accordingly they've developed such apps, and they've made it uh, into the market, penetrated into the market, and eventually have become successful. This is just a very small list out of n number of such applications which are in frequent use by various consumers across India, or I would say across the world. As the screen says, that the creativity is all about different aspects of a human mind, that what your imagination is, what your overall learning or background or how your perception is towards looking at a problem, how you, when I say you, it may be you as an individual or your team, brainstorm that problem, try to come up with a solution which is really practical, viable, and it is appealing to the consumer, and eventually the market accepts it. So the creativity is looked at in a various aspects. Coming to the forms of creativity which are eventually going to be protected under different forms of intellectual property rights are, as we can see on the screen right now. When we look at creativity as an invention, which is backed by some scientific elements, they are eventually going to be protected by patent law. One of the famous, profound creator we can look up to is Mr. Henry Ford. Then if creativity is all about communicating through different forms, they're protected under copyright. I'm respectfully quoting the creator as Mr. Rabindranath Tagore. Then when creativity is in form of a brand or a trade name, then it is going to be protected under Trademark Act. Various examples are there. Just to name a single right now is Nike, and I'm sure my dear participants would agree with me that how they have been communicating as a brand to the consumer. Then is aesthetic creativity, which is appealing to eye, is eventually going to be protected under Design Act. And again, there are many of them, but just to quote one is Apple as a design element. So interestingly, emoji, as we are using so frequently, I think n number of times in a day we are using emojis now. But those emojis are once protected under copyright, then they are also protected under trademarks when they have a specific element associated with them. And when they are ornamental or having some non-functional design, they can also be protected under design rights. So the simple emojis which are merely part of our life are also protected by different intellectual property. Isn't it interesting? So now what is intellectual properties? It's a word having two different elements called intellectual and property. Now when we say property, of course, something which you are possessing. And when we say intellectual, it's something coming from a human's mind. So a property which is created from a human's mind is referred to as intellectual property. It is intangible in nature. We can't feel it. We can just think and imagine it at the beginning. But over a course of time, we are going to make some physical object out of it. Now that very physical object is going to become our property, and it is going to be protected under respective regime, respective form of the law. And believe me, they are not about lawyers, they are all about creators. We as lawyers are here to protect them. But whose properties are we protecting? Of all those innovators, of all those designers, of all those script writers, for all those painters, and also for creating different business models and business entities. So we are here to protect you. It is not only about lawyers. And having one or more intellectual property will really make your business presence strong. Your worth is going to be uplifted significantly, and your goodwill shall be eventually be established. Having this intellectual property, or with a wish to possess at least one intellectual property, as an individual, I would always wonder that what am I supposed to do? What am I supposed to create? Which kind of efforts I should put in? So those efforts can be one or more, which I've listed right now. Primarily, they have to be creative. They have to be unique, meaning thereby those efforts or those intellectual property should not be copied or kind of inspired by others, and you should not be imitating somebody else's intellectual property. So they have to be creative and new in its form. These efforts can be in the form of literary, in the form of artistic. Many a times it is in the form of expression of your thoughts, aesthetic, as I've said, and they're often in the form of problem solving efforts, meaning thereby you have a problem, you're seeing a problem and you want to solve a problem. Putting in efforts to solve a problem, you come up with a solution. Now that very solution is something which can be protected under intellectual property law, at times patent laws. But they all are supposed to be the intellectual efforts, and they are going to be commercialized and monopolized by intellectual property law. Having monopoly, having commercial exploitation, the intellectual property laws have been playing significant role in building up a startup, building up an entity, building up an entrepreneurship as a whole. Now, what is expected from you to invest? Primarily your time, then your energy, your focus, and the respective amount of your money or your funding. When these three elements are properly given and your creative efforts are infused, then I'm sure you shall be able to create your intellectual property and identify it and protect it. Before moving ahead, I would like to really share with you that all of us are creative. We are doing things even in everyday activity. We are trying to do our daily activities in a better way, in a smoother way, may it be office or may it be at our home front. At times in the office, we try to solve a persistent problem, and we deploy sometimes software, sometimes devices to make it happen, to faster certain processes. So I put in two new words called software and devices. Now, when I say software, they are also protected under intellectual property law. When I say devices, they are also protected under intellectual property law. So while you put in efforts to make things better, the creativity automatically flows in and your intellectual property is created. But it is up to you to identify that yes, the creativity has taken place and it is in the form of protection. So in the coming slide, we are going to see that what kind of creativity would be eventually be converted into intellectual property form. Just to brief the various benefits, I've just tried to squeeze into a few of them right now in front of me. You really get the exclusivity to use it. So the intellectual property rights are basically monopolistic in nature. So when you possess an intellectual property, you as an applicant or you as an owner can only use it, and you can restrict all others to or not to use it, not to exploit it without your permission. It recognizes the right as the ownership. Now, having the ownership over certain intellectual property is really a matter of pride and really matter of adding value to the enterprise. Moving ahead, you can, since you're owning a property, you can act on it and you can exploit it in various fashion. You can outrightly sell, you can offer license, you can assign, and as well as you can transfer the right. Even intellectual property rights are inheritable in nature. So all the elements of properties are associated with the intellectual property. So after the death of the owner of an intellectual property, it is inherited to the legal heir of that owner. So now this is very interesting point that it says it safeguards your moral rights. I would say when you invest your time, money, and energy, you really get associated with that very project, that very creativity, and your emotional attachment, your really goes strong, and you want to protect it completely. So you will really not like if somebody else misused it. So your all moral rights, your emotional rights are safeguarded. When we look at it, the business angle, a property gets the investment. Precisely, a protected intellectual property will attract investment. It's generally the market respects one which is protected, not one which is unprotected, because unprotected might invite a lot of issues in future. So the first question of investor would be, do you own an IP? And I suggest all my viewers and participants right now to make sure that before they meet any investor, they must have one or more IP in hand to have a fruitful conversation. The last advantage is listed here is it enhances the value of your business. Believe me, the intellectual property valuation is the one which is on the top of the valuation chart. The physical assets has now reduced its charm, and it is no longer the one which is counted as the valuation element as much as the intellectual property valuation. So if I have a strong trademark with me, and if I even don't own a single office, I may be renting it out, or my office I'm using is on rent, then also my mere strong trademark valuation will bring in more business value than having those physical assets. So I'm excited to share that which can be the intellectual property, which are different forms. Primarily, they are patent, trademark, design, and copyright. The second tier of the intellectual properties are geographical indication, trade secret, and semiconductor layout design. In this presentation, I'm going to talk about patent, design, trademark, copyright, as well as geographical indications. So I think we all are creative. We all want to possess one or more intellectual property. We are thinking, we are imagining, we have one or more idea. Now we are excited to to understand and protect each idea which I have right now. So my first equation can be when I have an idea and I'm expressing in a certain format, my idea is going to be protected under Copyright Act. The next idea, if I have and it is associated with innovation as well as invention, then it shall be protected under Patents Act. If I have an idea which is associated with quality or identity or trade values, then it is going to be protected under Trademark Act. And whenever I have an idea which only deals with appearance or aesthetic element of a product, then it is going to be protected under Design Act. All these 4 acts or even all these different pointers which are like 7 acts, they all are distinct. They all have different rights to offer. They all have different salient features of them, right? So let us see the first of it called Trademark Act. And I would like to take you to this screen, which has a few trademark, and I'm sure we are dealing with them, we are seeing them, we are using them quite frequently, right? So we have an element on our left hand side, or we have a logo on our left hand side called IIM Ahmedabad. Now, the pattern over it is also protected under trademark. The name IIM Ahmedabad is also protected. Similarly, Khadi Bharat is also protected as a brand. Interestingly, our Incredible India Atulya Bharat is also registered under Trademark Act. Our very dear Amul is a popular or a well-known trademark. So is Adani. State Bank of India, and then what we have in front of us is yjtrivedi&co, where I serve as a senior partner, is also registered under Trademark Act. So different business sectors with having a brand name, all of them are going to be protected under Trademark Act. Now, what are the characteristics of a trademark? A trademark is a mark which has to be capable of being represented. It distinguishes one set of goods or services from all the others. So I have used an example of 2 different rice bran oil. Both are having different trademark. And a consumer is going to buy a particular rice bran oil by tagging or by communicating a particular trademark name. A consumer generally would say, give me Fortune rice bran oil, give me Aditi rice bran oil. And this is how the same product would be distinguished from the other set of products. The term of protection of a trademark is initially 10 years, and the owner is expected to renew every 10 years. Remember, trademark is having eternal protection, and you as an owner of the trademark is expected to renew every 10 years. So a trademark can be as old as 200, 300 years old also. And older the trademark, mightier it is, right? So having a trademark is like you are possessing a lifelong or even eternal intellectual property, which is a very special feature about trademark, and it is not so with any other intellectual property. Now, trademark may include name, word, symbol, design, logo, image, even sound, and combination of one or more of the list. It can also represent shape of the goods. We'll see certain examples of such trademarks. The packaging or even combination of colors works as a trademark, or you can file for such trademark application. The basic requirements while filing a trademark are, and these are all suggestive in nature, that it should be easy to pronounce and remember, it should spell correctly, and it should not be descriptive at all. And it should be as short as possible. Now, I would like to discuss this descriptive part. Now, when we say, I want to buy a Fortune rice bran oil, and if my trademark is chawal rice bran oil, then of course the rice bran oil is procured from chawal or rice. And if my name or my trade name is chawal, then it is really confusing and it does not serve as a legal or right trademark. So while you decide on your trademark, you kindly be really away from your goods. It should be very distinct from your goods. And if let's say if I say fresh fruit juice, then it is of course you want to serve fresh juice only to your consumer. So quality of goods should also not be used as a trade name. These are not the good trademarks, and they're often, or they're most of the time, objected by trademark authorities. Now, what can't be registrable at all? As per the section of Indian Trademark Act, a list is precisely given that these kind of trademark shall not be registrable at all. They are the names and gods, images of the god. Because such names and gods are not for a particular person or a company, they are for a larger community. They are never protected under Trademark Act or not assigned to a single person. When there are marks or terms which are completely contrary to public order morality, they are not allowed at all, keeping social interest in mind. And when it comes to national interest, our flags or emblems, etc., shall not be allowed as a registrable trademark. Now, this slide speaks a lot about what kind of different trademarks or what different elements may be registered. So on my left, I have some word, logo, mark, label, and slogan. And we have used a few examples like Dabur, Apple, etc. And I think you all will agree that they really represent their word mark called Apple, their logo, their writing style, etc. When it comes to a combination, something on my right hand side, it's like you can have a combination like word and word or word plus a numeral. So you have Jivraj 9 as a trademark. You can even add a design with a word that is Nike. Similarly with Tata, right? And there are certain trademarks on my left bottom side are like they're suggestive, descriptive, even arbitrary. They are like different drugs or Band-Aid, etc. descriptive in nature. And recently, the non-traditional marks have been introduced by Trademark Act and they are now protected. There are different sounds such as opening sound of Microsoft, Nokia devices, etc. are registered under sound trademark before Indian Trademark Registry. Even fragrances which are unique and they're the identity of a particular product, then such smell mark have also been registered under Indian Trademark Registry. So interestingly, there are plethora of trademark you can think of, but each of them must have a uniqueness in them. So if I already have Amul with me as a trademark, then my next trademark should be not at all Amul, which is same, but I must add creativity here to have a new and unique word. And believe me, the creativity is endless, and we often receive various WhatsApp forwards saying that anybody knows how Adidas was formed. A stands for something, B stands for something, right? And that is how different and unique or at times weird trademarks were created and eventually protected, and they have become really popular. But having generic or popular names is not a good suggestion to have such trademarks with your business identity. I would like to share a few case study quickly. One of them is the Forest Essential, which is a very fresh trade and business activity. It was founded just 20 years back with a small capital, but eventually they have been able to penetrate it, and they're doing fairly good business. But their strong presence of the brand caught attention of a global giant, a fashion company, a cosmetic company precisely, and they acquired some 40% of stake in the company. The strength of this company in terms of intellectual properties, they own trademarks and copyrights, and they are all well applied and well protected. Now, interesting case about Starbucks. Here you will believe me or not, but Starbucks has ended as a loser. So the story goes something like this. There is Bees of Bloomsbury, called a London-based small cafe, and they introduced a trademark combining muffin and donut, and they filed a trademark application for Duffin, and it was becoming popular. Duffin was a registered trademark owned by Bees Bloomsbury. Eventually, Starbucks came up with this brand called Duffin. This matter went into the court. The court held that since Duffin is a trademark of Bees Bloomsbury, Starbucks can't use it. So Starbucks has to drop its trademark or its all trade activities with the name Duffin. So no matter whether you are big or small, it's all about having your trademark well protected. And you can often give a good fight to the giants. Okay, I'm switching to the next intellectual property regime called copyright. Very interesting, and I would firstly want to take you to certain examples. So I have in front of me an example of TVF, the viral fever. It's one of the popular streaming platform these days, and you'll find it in various platforms called maybe YouTube, Netflix, and at various other places. What do they produce? They produce web series or videos. They create various contents. Now, while doing so, what they have created? Now, each of their series is, let's say, creatively developed, creatively prepared. And in that process, they could get various copyright contents, right? And the TVF logo is protected under Trademark Act, and they are eventually owning trademark as well as copyright. The same applies with Comedy Factory, another content developer, the comedy creators. Each of their contents is protected under copyright, and they often share their views on copyright, and they always make sure that they do not violate somebody else's content. Now, what we have on our left hand side as the Comedy Factory is their trademark, and whatever contents they create are all copyright contents. They are all protected contents. Now, then what comes under copyright? So, copyright is an exclusive set of rights which are awarded to the creator, the one who created it. But unlike trademark, they are awarded for a limited period of time. They are given or they are credited to the creator against the creation of their work. And it's a form of intellectual property, which is in the form of expression. It has to be substantive and discrete. That was the theory part. If I see the practicality or the actual articles created out of it, so that the list is really long. So whenever there is a literary work which is created in the form of novel, poem, plays, reference work, magazines, newspaper, computer programs, manuals, websites, they are all going to be protected under copyright. All our artistic expressions. So my creativity this time is going to be expressed in the form of artistic creativity. So it is many a times paintings, drawings, photographs, even sculptures. These are also protected under Copyright Act. There is a separate segment and it is treated separately under Copyright Act. There are films, the musical compositions, and even choreography is protected under copyright. The last list goes like this, and very interestingly, even our maps are copyright protected. The technical drawings, the blueprints, etc., are also protected under copyright because they're really important asset to the industry. The databases, as we know, the value of data, the databases are protected under a copyright, and the advertisements are also protected under copyright. So a lot of creativity is covered under copyright, and I've just tried to have a list or a few examples in front of us. So Amul mascot, as we very fondly watch or use, is protected under copyright. So is various musical compositions. The jingles of certain brands are protected, very well protected under copyright, and the copyright owners make sure that nobody infringes such copyrighted creations. Our websites, whatever we create on website, are also protected under copyright, so as manuals. The term of protection is 60 years from the date of creation. And in case of the literary or dramatic work, it is the life of the copyright owner and 60 years are added into it. But when it is in the case of cinematography, the movies, etc., 25 years are awarded as a copyright protection. So different countings are there, as that depends on what kind of contents or what kind of copyright you have created. Or just like to quote one example here, maybe some 15 years back, this case or this incident or this infringement took place. Ram Sampath is a music composer. He prepared a jingle, and that jingle was used in a particular advertisement. In that advertisement, one of the Roshan family's actor acted in that jingle, in that advertisement. Eventually, that Roshan brothers produced a movie called Crazy 4. And they used that jingle or that piece of music in their movie in the form of a song. Now, this was done without the permission or any financial understanding with the music composer Ram Sampath. Ram Sampath realized the importance of its copyrighted creation. He went to court, and court held that this amounts to an infringement. And the settlement took place, and even before 15 years, this settlement was bearing a good amount of some 2 crores. So you can understand the gravity of owning good copyright with you. And then when infringement takes place, the owner must go and protect it. Okay, moving to the next intellectual property, that is design application. So in front of us, there are different cycles. And of course, the purpose remains the same, called cycling. Their main parts or components broadly remain the same: wheels, tires, brakes, seat, pedals, etc. But each one looks different. So now when they look different, they are distinct from one another, then they can be registered under Design Act. Now, interestingly, our Apple mobile phones or other mobile phones are protected under Design Act. Then even the dress prepared or designed by designer named Sabyasachi is also protected under Design Act. Interestingly, Sabyasachi is one of the highest filer of design application and has crossed some 550 design application this year. Each of its unique creation or unique creativity, he makes sure that it is protected under Design Act. And that's how he builds his intellectual property portfolio. All different water bottles, or precisely mineral water bottles, having different shapes, can be registrable under Design Act. Same applies to the cars or other automobile vehicles. Now, what are the requirements of filing a design application? So, design rights are granted to only aesthetic or outer looks. When design rights are granted, the functioning or technicalities of the article is not awarded or not granted. It is just about the outer look only. So when I look at this mouse, the outer look or its shape is going to be registered under Design Act. It has nothing to do with its trademark, that is Logitech, or it has nothing to do with how it communicates with my CPU. So functionality is not going to be covered, it's just about its shape. It also covers contours, colors, lines, even textures are also protected under Design Act. But one thing, when we must make sure that they are going to be judged only or solely by eyes. Okay, the protection is 10 years and it can be further renewed for 5 years. So I just recall that trademark term of protection is eternal. If you keep on renewing, then its copyright, it is variable, but roughly 60 years. When it comes to design, it is 10 years with a renewable period of 5 years. Every design, while filed, the creator must make sure that it is original and novel. It should not be infringing or copying of an existing design. And it should be significantly distinguishable. It should not be merely having small changes. It should be really significantly different. One must make sure that no prior publication is made. And further to it, it should be applied to an object. It should not be imaginary. So coming to the example, that on my right hand side, there was a registration made for a design of a solar tree. While making the registration, we have to provide certain views of that object. And on the left hand side, you can see the actual installation of the same design. Our TDW Furniture, an Ahmedabad-based company, has been really prolific filer in furniture design, and each one of it is having its unique element of design. In this pandemic time, something really nice happened, and that was all around design and intellectual property, but that was also for good of the society. A Noida-based healthcare setup, they designed a compact size ventilator. It caught attention, and the government ordered for some 10,000 pieces of this designed, registered ventilator. And that was a big news in the early phase of the lockdown. So you can see the strength of a simple design. Geographical indication is the next intellectual property. It pertains to a particular location, and then whatever produce or traditional products which are procured or created in that region are granted GI or geographical indication rights. We can see a list called, let's say, Banarasi sari. It clearly says that sari is from a region named Banarasi. When we say Darjeeling tea, it is for Darjeeling area. It is different than even Assam tea, or even different than the Nilgiri teas. And they are always granted, the GIs are granted to a community or a cooperative society. They are never granted to an individual person, because the GIs are one which is related to that region, not to a person. The last format of intellectual property, which has much to do with scientific efforts, a problem solving effort, is called intellectual property, namely patent. The patents are granted to what? Let's see that first. The patents may be granted to a new or novel product or process. It can be also granted to machine or even apparatus. Any article of manufacture, compositions of matter such as chemical compounds, physical mixtures, even pharmaceutical products are granted patent. The improvements or combinations of one or more of above points can also be granted patent. Simple, interdisciplinary items, products or process are also granted patent. What it must have is, it has to be novel. It has to have an inventive step, that is substantial scientific efforts are put in to procure or to prove the productivity or efficacy of that product, and it must be industrially positively applicable. If these three criteria are met with, the patents are granted. Now let's see what kind of patents have been granted. So some 50-60 years ago, the ring pool cane, having such innovation, was granted patent, and Coca-Cola paid good amount of license fee to this inventor, and that was really a big news. And you can see the numbers in front of me for having such a small, sweet invention and patent being owned. And who took interest? Maybe a giant took interest, and you may be paid good amount of royalty. Interestingly, Biocon is a pharma company, and it is, of course, an R&D based biopharmaceutical company. The journey of Biocon is really long and inspiring, but what specific elements we should look into it is, they're owning some 1,200 intellectual property, out of which there are 984 patents and 448 trademark registration. So this is the strength of that company, and then you can see the valuation of that company. Moving back, we'll see what is essentially required while filing a patent. While filing a patent, there are two roadmaps. The invention, when you have realized that there is an invention, and if you all make it publicly available by some publication or by some commercial activity, it amounts to the publication. So once published, the patent right shall not be granted to you. So there will not be monopoly over that invention, and you will really lose the important rights of invention. At the same time, if you as an inventor choose the path of having an invention, filing a patent application, and then making any publication or any trade activity, that is really advisable and wise to go as a business activity. You will have your patent application in your name, a monopoly right, and you shall also be able to do the commercial activity. So we strongly advise you not to publish your patent or your invention. First file and then make the publication. Now the patents rights are granted by Government of India. They are very exclusive in nature. They are meant to encourage technical and economic development. And once you have the patent rights, you can really exclude any other from making, using, selling, or even importing that invention in India. So this is the strength of patent. Right? The patents are granted for 20 years. So the lifetime here is again not eternal like trademark. They are for a specific period of 20 years. Now we have gone through different intellectual properties. Let's summarize. They were trademark, then they were copyright, then design, then geographical indication, and then the last one was patent. Many of them were having common properties or common characteristics. At the same time, they had very salient or specific characteristics also. But while we think about any object, we really need to see what can there be a possibility of owning or having more than one intellectual property? The answer is really yes. You can see the example in front of us that if I look at the pen, very commonly used element, all different intellectual properties are covered. So you have a trademark, whatever the brand name of this pen, that is, let's say Parker. So you have a Parker as your trademark. Then you have a copyright, that is the artwork or color combination of the pen can also be protected. Even the artwork of the brand can also be protected under copyright. The very specific design or its configuration can be protected under design. And let's say the nib of a pen, when it is, performing certain activity of having a very specific performance of, let's say it's writing very smoothly, or it is saving ink, etc., then it can be applied for the patent. So a single product can consist of more than one intellectual property, and I'm sure each one of us are using such elements in our daily use, but probably we may or may not be knowing that the intellectual properties are imbibed into them, and we are really respecting that object because it is owning a particular intellectual property. Let's say we take pride in using a product of a particular brand. Now, when you say brand, it's of course a trademark, and you really take pride or happiness while you're using a particular brand because it stands for certain quality, certain identity. So we are using intellectual property. Now, this is the time for us, or for all of us, to think about creatively developing such intellectual property, identifying them, and make sure that you really protect them. Because if you do not protect, somebody else will take its procurement in their name. So creativity, intellectual property, and economical growth, they are really, really into a positive circle. So whatever is created, when protected, it fuels up economic growth. And when it is economically growing enterprise, it has to happen that new creativity would take place, and eventually IP protection, and so as the economic growth. So it's a very, very positive and productive circle. And I wish you all to get into such circle and make the best of it. I'm getting close to the end of my presentation, and I would really like to share some thought of intellectual property. Now, while owning or while creating my intellectual property, I'm so excited. I'm really caring or possessive about my intellectual property. I'm sure that all others must be feeling the same for their intellectual property. So, it's my responsibility to respect others' IPR too. So while I protect my IPR, I should not infringe, maybe knowingly or unknowingly. I should not be infringing others' IPR also. So this is something out of my experience, that you kindly make sure that you respect others' IPRs also. In turn, it would create a good image of your product, your business identity. At the same time, this shall not bring legal complications in the future. So, so keep creating and keep protecting and keep growing. Thank you everyone for your patient hearing, and I'm really glad to be here today and obliged to GUSEC, IPPO for giving me this opportunity and sharing my thoughts. Being virtual, I really can't see the expression or the feeling of my participants, but I'm really glad to be here. So thank you. Over to Priyanka and Malay.
Yes, ma'am. There are few of the questions. So the first question is, can a trademark registered in India be protected in other countries automatically?
Uh, the word automatically is something to be talked about. When you file a trademark application in India, it is eventually going to be protected in India only. So if you want to protect in other countries, you have to do the similar activity of filing in the respective country. You do not get the automatic rights.
Okay. The next question is, what about if someone have vintage item like painting furniture, which IPR is applicable to protect someone owing rights?
Can you please repeat the question? Your voice was not very audible.
Yes, ma'am. So the question is, what about if someone have vintage item like painting furniture, which IPR is applicable to protect someone owing rights?
So let me understand this question, that if there is a vintage item and being owned by someone, can they file design application? Am I correct?
Yes, even I don't understand the question. I'm so sorry.
Can you type for me? I can really. Okay. So Mr. Manish Goel is asking,
Yes.
what about if someone have vintage item like painting or furniture? Which IPR is applicable to protect someone owning the rights? Now,
Yes.
when you say vintage item and when there is a painting, it goes into copyright. We have to really look at the very item, and every item is different, and so as the protection is different. So when it is painting, it is copyright. When it is furniture, it is design. And likewise, for each item, we have to advise and analyze separately.
Okay. Next question is, how can we protect choreographic works?
The choreography is protected under copyright. So you need to submit your choreography in a video format before the copyright authority, and then they eventually will grant you the copyright certificate. Of course, you have to go through the due procedure of the same.
Okay. The next question is, please share some insight about service mark and difference with trademark.
Uh, my answer would go like this. I have service mark and then I have a trademark. Its name speak a lot about the activity. When you say trademark, it pertains to trade activity, right? So some kind of selling of the items and consumers buying those items, and those activities would fall under trademark. When you say service mark is one where the entity provides the services and the consumers or the beneficiaries would avail those services, right? So say, let's say our legal form. So our yjtrivedi company is protected under service mark, right? But at the same time, brands like Amul, Jivraj 9, Tata, etc., they do not provide service. They actually trade the goods, so they are protected under trademark.
The next is patent expires automatically after 20 years?
Answer is yes. It's an automatic event.
Okay. The next is, how much is charged for first time of filing an application? Do also let me know about renewal period and charges of IP.
Dear Mr. Vivek, this is really a very broad question because you are asking me about different, I mean, charges of different IPs. So what I have just narrated, there were some 5 IPs, and each IP has different filing procedures. Each one will ask you what type of applicant are you, and accordingly they will expect certain charges to be paid. So kindly allow me if I'm not able to answer your question here. But GUSEC has all these charges with them, and they can better give you the answer. But before this, I would suggest you that how if you can, be specific that which IP you have created.
Um, the next is, how to know if someone else is using your copyright or trademark content.
It is on the onus of the owner. Whenever you talk about property, may it be intellectual property or physical property, the owner has to be vigilant about whether somebody else is misusing their property or not, right? So it is the owner who has to make sure that nobody else is using, and when they come into the knowledge that somebody else is misusing their copyright or trademark content, they should take necessary action.
The next is, how can we get information about other countries' patent is in India? About
We
design
can
and
be
patent.
yeah, we can be thankful to internet and the search engines which we are using extensively. So the internet will help you to get information about patents of different countries across the world.
So, thank you, ma'am. I guess we answered most of the questions here.
Thank you.
The one interesting question that I am getting, Chirag is asking, I have wrote several books on account, commerce, finance, etc. If someone use my book content, has to prove the copyright. Yes, I guess all the content you need to secure through a copyright, and then you can claim if anyone copies from your content.
I would just add here, Malay, that the
Sure.
copyright is actually an automatic right, autonomous right to be precise. But when, as a proof of evidence, the copyright registration is essential,
Right.
right?
So yeah, so thank you, ma'am. I would on the screen after we conclude, you can take up the quiz, and once the quiz you take, we'll be sending the certificates within the 15 working days to your registered email ID as mentioned in the quiz. So thank you everyone for joining in. Thank you, Gopi ma'am, and thank you team for helping us out. Thank you.
Thank you. Stay safe.